Good day, class. This is Attorney Season, and welcome to Criminal Law Book 1. For today's lesson, we will tackle the definition of criminal law, definition of crime, felony, infraction, offenses, okay, and more. Okay, so please take down notes. So let's start. Okay, what is criminal law? So criminal law is a branch or division of law which defines crimes, treats of their nature, and provides for their punishment. Okay? Now, why is criminal law a branch or division of laws? Criminal law is a branch or division of laws because here in the Philippines, we have so many laws. We have labor law, administrative law, remedial law, okay, and the likes. Therefore, criminal law is only a branch or division of the law. And also, you should take note that criminal law is a public law. Why is criminal law a public law? It is a public law because criminal law, okay, applies to the general public. Okay? It applies to all persons who live or sojourn in the Philippines. And also, you should take note that criminal law is considered as a municipal law. Why is it considered as a municipal law? Because criminal law is territorial in nature. It is enforceable only within the Philippine territory. Okay? And criminal law, okay, defines crimes. Okay, one good example is the definition of theft, okay, under the revised penal code. So, theft, what is theft? So, theft is the taking of a personal property belonging to another person, of course, with intent to gain, and without violence or intimidation against persons, nor force upon things. Because if there's violence against or intimidation against persons and force upon things, then that's what? Robbery. Okay? Now, next, traits of their nature. What do you mean by traits of their nature? So this pertains to the elements of the crime. Always remember that, okay, every crime has elements. Like, again, theft. Okay? What is theft? So first element, it is the taking of personal property. What's a personal property? It's something that can be moved. Okay? Unlike a real property, which is cannot be moved, like a house and lot, okay, etc. Uh, Always remember that in the Philippines, you can be only convicted of a crime as long as all the elements are present. Let's go back. So elements of theft, the taking of personal property. Second element, belonging to another person, okay, or belonging to the victim. Third, with intent to gain. And fourth, without violence against or intimidation against persons. So that pertains to traits of their nature. Because why? If the taking, okay, is accompanied with violence or intimidation against persons, then the crime is not theft but robbery with violence against or intimidation against persons. Okay. Always remember that under the revised penal code, we have two types of robbery. Robbery with violence against or intimidation against persons, and robbery with the use of force upon things. Okay. And lastly, provides for their punishment. Okay. One good example again in criminal law. Okay. Article 308, which punishes theft. Okay, di ba? It defines there what is theft. And below, okay, it provides for their punishment. It provides for the punishment if you will commit the crime of theft. Either, okay, what are the kinds of punishment under the revised penal code? We have a fine, okay, or arresto minor, arresto mayor, prisión correccional, prisión mayor, reclusión temporal, or reclusion perpetua, or maybe death penalty, okay, if applicable. Or under special penal laws, we have life imprisonment, okay, as the case may be. So I hope you learned a lot about the definition of criminal law. Now, what is a crime? So crime is an act committed or omitted in violation of a public law forbidding or commanding it. So if you will commit an act, okay, that is punishable by law, you are already committing a crime. Always remember that crime is a general term. It has what? Three branches. Like felony. What's a felony? It is an act or omission punishable by the revised penal code. From Article 114, that's treason, to Article 365 for imprudence and negligence. Okay? What are other examples of felonies? We have crimes against property, like theft, qualified theft, robbery, crimes against persons. We have murder, rape, homicide, parricide, infanticide, okay, etc. Okay, those are examples of acts that is in violation of the revised penal code. Another, we have offenses. What are offenses? They are acts or omission punishable by special penal laws, like RA 9165, the Comprehensive and Dangerous Drugs Act of 2002. And we also have infractions, or those acts which are in violation of local or city ordinances. Okay, like jaywalking. Okay. So again, if you will commit, okay, or omit an act that is in violation of a public law, okay, you are already committing a crime. Public law again, meaning it is what? It is applicable to all. A law that is applicable to all. Always remember that criminal law is a law that is applicable to all. And we have examples or sources of criminal law. So so criminal law does not only pertain to Act number 3815, the revised penal code, but it includes special penal laws, batasang pambansa, and what? Penal presidential decrees issued during martial law. Okay? Before the 1987 Philippine Constitution, a president, okay, can create or make laws. Okay? Because the legislative department and executive department are merged, okay, into one. Okay? Therefore, a president can create laws. Unlike now, okay, under the 1987 Philippine Constitution, our government is divided into three departments or branches. So we have the legislative branch. Okay, they are in charge of amending, creating, and acting a law. Okay, the executive branch or department, they are in charge of executing the laws, and we have the judiciary. Okay, they are in charge with the interpretation of the law, whether the penalties are excessive or not, or whether, okay, uh, the law is constitutional or unconstitutional. Okay, let's move on. So if a person will commit a crime, of course, two injuries will be caused. Okay, so if a person commits a crime, there will be two injuries that he will cause. Number one is social injury, and second is the personal injury. So what's the difference between social and personal injury? So social injury is produced, okay, by the criminal act. So if a person will commit a criminal act, okay, it will what? It will create, okay, a sense of danger to the community. Therefore, okay, it is repaired through the imposition of a corresponding penalty. Always remember, if you will commit a crime, okay, or an offense, it is automatically an offense against the state rather than the offended party. Therefore, okay, ang mga cases na to, it is always people of the Philippines versus the accused. Okay, in criminal cases. But in civil cases, it's always Juan de la Cruz versus Juan de la Cruz. But in criminal cases, it's always people of the Philippines versus the accused. Okay, so second injury, we have personal injury. So of course, if you will commit a crime, you will what? Produce personal injury to the victim. Okay? And okay, it is repaired through what? Indemnity, which is civil in nature. So if you will commit a crime, there's a corresponding what? Penalty. Okay? And indemnity. So example, so A shot B. Okay? And then B sustained a fatal wound, but he survived. Thereafter, B filed a prostrated homicide case against A. The fiscal found probable cause. In the information filed with the fiscal, the title is People of the Philippines versus A, the accused. Okay? So take note, in criminal cases, it's always People of the Philippines versus the accused. So the trial continued, and the judge found the accused guilty beyond reasonable doubt. Always remember, class, that you can only be convicted, okay, by the quantum of proof of guilt beyond reasonable doubt in criminal cases. In civil cases, that's preponderance of evidence. But in criminal cases, it's always proof of guilt beyond reasonable doubt. If the proof of guilt is only reasonable doubt, then the judge must acquit the accused. Can only convict, or the judge can only convict a person or the accused by proof of guilt beyond reasonable doubt. So here, in this example, the penalty is what? Imprisonment due to the social injury. Again, if you will commit a crime, two classes of injury will occur. Number one is social, second is personal injury. And aside from this, A will pay what? Civil indemnity or damages to B for what? The personal injury. Of course, if you will commit a crime, you will punch the victim. Of course, he will incur medical expenses. Okay, and what? Loss of income capacity. Maybe he will be admitted for 3 days, okay, or more. So you need to pay civil damages. Okay. So definition of terms. So there are three kinds of crimes. Okay. So we have felony, or acts or omissions, punishable by the revised penal code. So what are examples of acts or omissions under the revised penal code? We have murder, homicide, parricide, robbery, theft, qualified theft. Okay, those are acts that are punished by the revised penal code. By the way, what are acts? So acts are any bodily movement tending to produce an effect to the external world. Now, what's an overt act? It's an act that is directly connected with the offense that is being committed, like the act of stabbing, the act of pointing a gun at another person, etc. So that's an overt act, okay, that is directly connected to the offense being committed. The act of opening the door of a house that is not yours, okay? The act of stealing, okay? Omissions. What are omissions? So acts. Omissions are the failure to perform a positive duty required by law. One good example is when a person found a lost property. Okay, under the law, you should turn over such lost and found property to the rightful owner or to the local authorities. Otherwise, you will be held liable for theft. Okay. Next, offense or offenses. So these are acts or omissions punishable by special laws. Again, what are examples of special laws? We have RA 9165, Comprehensive Dangerous Drugs Act of 2002, RA 9262, okay, and the next. Infractions, or those punished by ordinances or local legislation. What are examples of ordinances? Like jaywalking, okay, no littering, vandalism, etc. Okay, or curfew violations. And those are examples of infractions. So take note that all three, okay, felony, offense, infractions are under the umbrella term of crime. And who has the power to enact penal laws? Enact meaning to create or make laws. Okay? So as a general rule, it is the legislative department. Okay? They have the power to enact penal laws. Okay? Legislative Department, otherwise known as Congress. Okay? It is the Congress of the Philippines, the House of the House of Representatives and the Senate. Okay? Our senators, our congressmen can what? Create laws. Okay? And is the power of Congress to create laws absolute? The answer is no. There are certain limitations. So, limitations to the power of Congress to enact penal laws. So, here are the 5 limitations of the power of Congress to create or enact penal laws. So, number 1 is penal laws must be general in application. This means that criminal laws, like the special penal laws, the revised penal code, must be applicable to all persons who live or sojourn in the Philippines. Otherwise, it will be violative of the Equal Protection Clause under the Bill of Rights, the 1987 Philippine Constitution, Article 3, Bill of Rights. Okay? And second, it must not partake the nature of an ex post facto law. What's an ex post facto law? An ex post facto law makes criminal an act done before the passage of the law, and which was innocent when done, and punishes such an act. So let's just say, okay, you have committed an act today, okay, that is not punishable by law, and then tomorrow, uh, the Congress will create a law, okay, that punishes the act that you have committed yesterday. Okay, that is not allowed. Why? Because it will be an ex post facto law. It will have a retroactivity. Always remember that in the Philippines, we follow the Latin legal maxim, nullum crimen nulla pena sine lege, which means that there is no crime when there is no law punishing it. Okay, so take note of that. Letter B, it aggravates a crime or makes it greater than it was when committed. Okay. C, changes the punishment and inflicts greater punishment that the law annexed to the crime, okay, when committed. Let's just say you have committed what? A robbery, and the penalty for the crime that you have committed is reclusion temporal. But they created a law which inflicts greater punishment like death. Okay, that is not allowed. Okay. Letter D alters the rules of evidence and authorizes conviction upon less or different testimony than the law required. Say for example, okay, in the crime of treason, you can only be convicted of treason when there's two witnesses. Okay? Treason follows the two witnesses rule. But if a law will be passed saying na only one witness is required to convict a person who committed treason, okay, okay, that's altering now the rules of evidence. Okay, because it authorizes conviction upon less or different testimony. Okay? And letter E, it assumes to regulate the civil rights, okay, of the citizens. Okay, and remedies. Which in turn, okay, imposes penalty or deprivation of a right or something which when done was lawful. Okay, and of course, letter F deprives a person accused of a crime some lawful protection to which he has been entitled. Say, for example, a person was convicted or acquitted, okay, or it was given an amnesty, and then there's a law, okay, passed revoking such amnesty. Okay, there's a law, okay, prohibiting uh there's a law that allows double jeopardy. That is not allowed. Okay, when you have been acquitted of a crime, when you have served your test sentence, okay, you cannot anymore beef be you cannot anymore serve the same sentence again. Why? Because that's double jeopardy. Okay? When you're acquitted of committing a crime, let's just say murder, okay, you have been acquitted. Uh, the victim, okay, or the family of the victim or the state cannot anymore file a case for murder, okay, against you for the same offense. Why? Because it's double jeopardy. Okay, and if you have already served your sentence and then after your release, hey, the victim filed a case against you for the same crime that you committed. Okay, that is not anymore allowed because you already served your sentence and that's double jeopardy. Okay, and number three, bill of attainder. What's a bill of attainder? Bill of attainder is a legislative act. Legislative act meaning an act coming from Congress which inflicts punishment without judicial trial. Always remember in the Philippines that we follow due process. What is due process? It's a law which hears before it condemns, which proceeds upon inquiry, and renders judgment only after a fair and public trial. Okay? Always remember there should be trial and then promulgation of judgment. Okay? A bill of attainder is not allowed. The essence of bill of attainder is a substitution of a legislative act for a judicial determination. So example, Congress passes a law which authorizes the arrest and imprisonment of communists without the benefit of a judicial trial. Always remember that every citizen of the Philippines is afforded with presumption of innocence. Okay? And there should always be due process. Okay? There should be proper filing of criminal cases, preliminary investigation if required, trial, presentation of evidence from the prosecution and from the defense, and then promulgation of judgment. Okay? So bawal ang legislative act i-substitute for the judicial determination. Okay? By the way, speaking of law, what is a law? So a law is what? It's a law. What's a law? According to Father Sanchez Roman, a law is a rule of conduct, okay? Just, obligatory, promulgated by legitimate authority, and of common observance and benefit. Okay? A law is a rule of conduct. Okay? So it lays down rules that the people should follow because if you will violate such rules or law, you will what suffer consequences. You will suffer the corresponding imprisonment or penalty. Okay? It's a rule of conduct. Just, of course, laws must be just and obligatory. It must be obligatory to all persons, okay, under the scope of the law and of common observance and benefit. Everyone must observe the law for their benefit. Because if you will not observe the law, there will be chaos, there will be anarchy. Okay? In order to have a just and orderly society, everyone must follow the law. Number four. So, of course, another limitation is Congress cannot impose cruel or excessive penalties. Let's just say you have committed an infraction and the punishment of such infraction is death. Okay? Okay? That's an excessive punishment. That's an excessive penalty. So, penalties should be commensurate, okay, with the crime that you have committed. If you will commit rape, of course, okay, that's a heinous crime. You could be held liable for reclusion perpetua, okay, or death, okay, as the case may be. But right now, death penalty is abolished. Okay. And fifth limitation, no person shall be held to answer for a criminal offense without due process of law. Okay, always remember, there should be due process of law. So, bawal ang bill of attainder. Again, what's due process of law? It's a law which hears before it condemns. Meaning, there's a judge who will listen to both parties and then give judgment. A law which hears before it condemns, which proceeds upon inquiry and renders judgment only after a fair trial. So we have here the characteristics of penal laws or criminal law. So number one, generality, territoriality, and prospectivity. Generality are persons to whom criminal law shall apply. Territoriality meaning the place where criminal law shall be applied. Always remember that under the territoriality principle, the revised penal code or criminal law is enforceable only within the Philippine territory. Prospectivity, it is the time when the law will apply. So generality, what do you mean by generality? So this means that criminal laws shall be applied to all persons on being within the Philippine territory, whether they are Filipino citizen or foreigners, regardless of any of their personal circumstances. So question, what if a Filipino citizen committed the crime of murder here in the Philippines? Can our criminal law, the revised penal code, apply to him? Of course, yes. Why? Because he committed the crime inside the Philippines. And all Filipino citizens, okay, regardless of their personal circumstances, penal laws shall be applied. Okay? What if a foreigner committed a crime here in the Philippines? Can our penal laws apply to him? The answer is yes, as long as he live or sojourn in the Philippines. It is criminal law, okay, is applicable to all so long as within the Philippines. And then applies to non-citizens since while they are within the Philippines, they are given protection in the same way that the government protects its own citizen. And for Article 14 of the Civil Code, it states there that penal laws shall be binding on all those who live or sojourn in the Philippines, whether citizen or not. Right? That's the principle of generality. And we have here the exemptions. The number one exemption is the generally accepted principles of public international law. Always remember, okay, that heads of state, chief of state, the president of another country, mga diplomatic heads such as ambassadors, public ministers enjoys what? Blanket of immunity from criminal jurisdiction of the country where they are assigned. Since they are immune, they cannot be arrested, prosecuted, or punished. Huh? That is what you call diplomatic immunity from suit. Okay? It is a well-established principle of international law that diplomatic representatives, such as ambassadors or public ministers and their official retinue, okay, possess immunity from criminal jurisdiction of the country of their sojourn and cannot be sued, arrested, and punished by the law of that country. That is what you call diplomatic immunity from suit. Let's just say there's a American ambassador, okay, who committed a crime inside the Philippines. Can he be prosecuted, arrested, and punished by our courts? The answer is no. Why? Because he enjoys diplomatic immunity from suit. Okay? And then we have here loss of preferential application. What do you mean by this? Laws which exempt certain individuals from criminal prosecution, such as members of Congress. Okay? Always remember that if you're an ordinary citizen and if you will commit libel, slander, or defamation against another person, you can be definitely held liable for such crimes. Okay, you'll be tried in court and be punished. But if you are a congressman, as long as there's a regular or special session, and if you have committed libel, slander, or defamation for every speech, okay, made in the House of Congress, you cannot be held liable. Why? Because of this, okay, a law which exempts uh, individuals from criminal prosecution. And under this, members of Congress, our congressmen and senators are immune. Okay? For every speech made in the House of Congress during regular or special session. If Congress is not in session, then they can be held liable. In but if Congress is in regular or special session, he cannot be held liable because this is an exemption to the generality characteristic of criminal. Okay? Law or laws of preferential application. Okay? And Number 3, we have treaties or treaty stipulation. So one good example of this treaty. Okay. By the way, what's a treaty? It's an agreement between two countries. Okay? And once there is an agreement, they should be complied with good faith. Pacta sunt servanda. Treaties must be complied with good faith. Okay? So another exception is the military basis agreement entered between the Philippines and the United States. Okay? So this is one good example of treaties or treaty stipulation. I believe it was mentioned in the basis agreement that if an American soldier will commit a crime against a fellow American soldier inside the Philippines, okay, it is the United States who will have jurisdiction, okay, over the said crime or case. But if it's an American soldier who committed a crime against a fellow Filipino citizen, it is the Philippines who will acquire jurisdiction over the case. Okay? So that's treaties or treaty stipulation. If it was agreed that the US will assume jurisdiction, okay, for a crime committed by an American soldier against an American soldier, then we should respect, okay, the agreement, the treaty, because pacta sunt servanda, treaties must be complied with good faith. Okay? Territoriality. What do you mean by territoriality? This means that penal laws shall be applicable only within the Philippine jurisdiction, including its what? Atmosphere, internal waters, okay? So as a general rule, take note that crimes committed outside the Philippine jurisdiction cannot be under Philippine courts. So let's just say you have committed the crime of parricide here in the Philippines. Okay? Pwede ba ka makasuhan under Philippine criminal laws? The answer is yes. Why? Because penal laws or criminal laws like the revised penal code, special penal laws, etc., is applicable only within the Philippine jurisdiction. But if you will commit a crime outside the country, okay? Okay? If you will commit a crime outside the country, you will not be under the jurisdiction of the Philippine courts. Why? Because, of course, the principle of territoriality. Penal laws shall be applicable only within the Philippine jurisdiction. Let's just say si A, okay, and si B legally married here in the Philippines. Si A nag-abroad. Si A met C. Then, nagpakasal sila dito. Now, can B charge A and C the crime of bigamy under the revised penal code? The answer is no. Why? Because penal laws shall be applicable only within the Philippine jurisdiction. If they are married here in the Philippines, of course, they can be held liable for bigamy. What's bigamy? It is the act of marrying twice. But if you will commit the crime of bigamy outside the country, you can be held liable for uh, bigamy under the revised penal code. Why? Because you have committed a crime outside the Philippine jurisdiction. But, okay, but B can file RA 9262 against A. Why? For emotional violence. Nga mo pwede maka-file og RA 9262? Nga nung dili pwede bigamy? Because in bigamy, ang elements of the crime is marrying twice. And wala mo sila nag-marry there sa Philippines but outside the country. Therefore, walay jurisdiction of Philippines. But for RE 9262, for psychological or emotional violence, pwede. Why? Because the effect, okay, naaman sa Philippines. Yes, A and C married there, okay, outside the country. But because of their marriage, because of A's infidelity, okay, of course, the legal wife, Miss B, okay, will what? Grieve, will suffer from emotional damages, psychological abuse, okay? And infidelity is an act of psychological abuse. And of course, asa man ang effect, asa man nag-uul si B here in the Philippines. Therefore, you, Miss B can file 926 RE 9262 case against A. Okay? And we have here exceptions. Article 2. Of course, Article 2 of the Revised Penal Code provides situations where the extraterritorial jurisdiction of the Revised Penal Code be applied. So, we'll discuss this later. Okay? So, one good example is when a crime is committed while inside a Philippine ship or airship. Okay? Let's just say, si Mr. E, nagsakay o PAL. Okay? PAL airplane. Okay? And then, he stole, okay, the cell phone of a fellow passenger. Okay? It, of course, okay, because of the territoriality nature of our penal laws, okay, Philippine the Philippines will have jurisdiction over the case. Okay? That's one good example, but we'll discuss this later. Prospectivity. What do you mean prospectivity? Meaning laws must look forward, okay, not backwards. So a penal law cannot make an act punishable in a manner in which it was not punishable when committed. Nullum crimen, nulla poena sine lege. There is no crime when there is no law punishing it. And as provided in Article 366 of the Revised Penal Code, crimes are punished under the laws in force at the time of their commission. Okay? Again, prospectivity, the law must look forward, not backwards. And we have here applications, a retroactive application of criminal law, the exceptions to the general rule. So if penal laws are favorable to the accused, provided that he is not a habitual criminal, then penal laws must be given retroactive application. Or if the penal law allows retroactivity. So let's just say a person committed a crime which carries a penalty of reclusion temporal. And then Congress passed a law, okay, which lessens the penalty of such crime to arresto mayor. Now, can the accused be given the benefit of the doubt? Can the new law apply to his case? Can he serve the new sentence, the lesser sentence? The answer is yes. Okay, provided okay he is not a habitual criminal. Why? Because the lesser sentence is favorable to the accused. But as a requirement, he should not be a habitual criminal. Okay? And of course, if the penal laws allows retroactivity, so there's a new law passed, and then okay, under the law, ningon nga, okay, we will allow retroactivity. So therefore, applicable, okay, as the case may be. We have here theories under the revised penal code. So under the classical theory, okay, so take note that okay, our penal code, the revised penal code, is mainly based under the classical theory. Okay, why? Because the basis of criminal liability in classical theory is human free will. Okay, so if you will commit a crime, of course you will suffer a corresponding penalty. Okay. So what is the purpose of penalty for under the classical theory? So the purpose is retribution. Okay, it evolves from the maxim an eye for an eye. Okay, oculo pro oculo, dente pro dente, an eye for an eye and a tooth for a tooth. Okay? Therefore, for every crime committed, there is what? A corresponding penalty based on the injury inflicted on the victim. Why? Because the basis of criminal activity is human free will. If a person commits a crime, okay, under the classical theory, this means that it is out of his free will. He really committed the crime. Therefore, okay, he really committed the crime voluntarily with intent. Okay, and he must suffer okay, corresponding penalty because the purpose of penalty under the classical theory is retribution. An eye for an eye. Oculo pro oculo. And we have here positivist theory. So, under the positivist theory, the basis of criminal liability is what? Man's social environment. Always remember that all men are born good. They only become evil due to the influence of the society or the community they belong. Because crime is a social phenomenon. Okay? And the purpose, okay, of penalty under the positivist theory is rehabilitation. Okay? So when the offender commits a crime, yes, he will be imprisoned, but to be rehabilitated so that he can go back to the mainstream of society as a rehabilitated person, a person who will not anymore commit crime. Okay? So offender is a socially sick individual who needs to be corrected, not to be punished. Okay, that's under the positivist theory. And penalties must not be what? Not only be retributive, but reformative. Okay? The goal of the positivist theory is to reform or to rehabilitate offenders. To what? To allow the convict or the offenders to live a new life and rejoin the society. Okay? As a productive and civic spirited member of the community. Okay? So we have here note. Okay? The revised penal code, take note, is based mainly on the classical school of thought, the classical theory. But okay, the revised penal code has some aspects okay that are based on positivist theory. So examples, we have the indeterminate sentence law. Okay, if you will serve your the minimum of your penalty, you are eligible for what? For parole. What's the purpose of parole? So you can go out of prison and what? Do something with your life. And the purpose of which is for rehabilitation. Para di ka masagol sa hardened criminals. You can go out after serving your minimum sentence. You will be given a chance to redeem yourself, to be good, to find a job. Okay? And probation law, 6 years and below. If you have committed a crime which carries a penalty less than 6 years, okay, you can apply for what? For probation. Okay? And once your probation is approved, you will report to your probation officer from time to time. And 9346, okay, this law abolished the death penalty. Okay, so these are examples of uh, the positivist theory. Utilitarian or protective theory. So in this theory, the purpose of punishment is to what? Protect the society from actual or potential wrongdoing. So even in violation of specific special penal laws, where intent does not matter, courts should see to it that punishment shall only be imposed to the actual or potential wrongdoers. Okay? So this is under utilitarian or protective theory. Dapat ang punishan is the actual or potential wrongdoers, not the innocent victims. Okay? So equipoise rule. Okay? What do you mean by equipoise rule? So this pertains to the principle that if the evidence, okay, in a criminal case is evenly balanced, or there is an equal amount of evidence both in favor or against the defendant's guilt, maybe balance on evidence of prosecution and the defense counsel, okay, then the accused should be what? Given the benefit of the doubt, and he must be acquitted. Always remember that the quantum of proof in criminal cases is proof of guilt beyond reasonable doubt. The prosecution must prove the guilt of the accused beyond reasonable doubt. Otherwise, the judge must acquit the accused. So this is the equipoise rule. Equipoise rule meaning it pertains to evidence. And if evidence is evenly balanced, so evidence of prosecution, evidence of defense, balance are good, okay? The accused should be given the benefit of the doubt and he must be acquitted. So, if the prosecution cannot establish the guilt of the accused beyond reasonable doubt, and the evidence is in equipoise, the defendant should not be found guilty. He should be acquitted. Okay? In dubio pro reo, what do you mean by this? So in English, when in doubt, rule for the accused. Okay? So it's a Latin legal maxim that translates to in doubt for the accused. This maxim embodies the principle that when there is doubt, okay, in a criminal case, the doubt should be what? Resolved in favor of the accused. So if there is insufficiency of evidence to establish guilt beyond reasonable doubt, like dili gud kaya ang evidence nga makaprove sa guilt beyond reasonable doubt sa accused, the accused should be given the benefit of doubt and should be acquitted. Here, rule of lenity. So, under the rule of lenity, it states that if there is ambiguity, meaning unclear ang criminal law, so there's an ambiguity or uncertainty in a criminal law or statute, the court should interpret the law in favor of the defendant. So, if there is ambiguity, unclear ang language of a criminal statute, it should be resolved in a way that is most favorable to the accused. Dapat favorable to the accused. Ang equipoise rule pertains to evidence. Okay? If evenly balanced, acquit. But in rule of lenity, this pertains to our statute, our criminal law. Okay? The revised penal code or the special penal laws. If unclear, if the law is ambiguous, if there is an ambiguity or uncertainty in criminal law, dapat i-interpret na siya in favor of the defendant or the accused. Okay? So, rule of lenity. Finality of acquittal doctrine. So, of course, after trial, okay, na-rest na ang prosecution, na-rest na ang defense, a judgment, the judge will render a judgment. And a judgment of acquittal is final and appealable. Always remember that. Once ma-acquit sa accused, it is considered final and unappealable. Otherwise, okay, there will be what? Double jeopardy, and that is in violation of the 1987 Philippine Constitution, the Bill of Rights. Okay? So, judgment of acquittal is final and unappealable. Di na ka pwede ma-file case o usog sa anang crime. Okay, why? Because a judgment of acquittal is final and unappealable. Hindi ka pwede maka-appeal sa Supreme Court. Okay? So what if what has been performed was a perverted or immoral act, but there is no law that punishes such an act? Can a person be prosecuted in court? The answer is no, because we follow the Latin legal maxim, nullum crimen, nulla pena sine lege. There is no crime when there is no law punishing it. Okay? So are there common law crimes in the Philippines? The answer is no, because the Philippines is a civil law country. We enact penal laws. Okay? Why? Because we follow the Latin legal maxim, nullum crimen, nulla pena sine lege. There is no crime when there is no law punishing it. Therefore, for every perverted or immoral act, there should be a corresponding law which punishes such act. Okay? So no, common law crimes are principles, usages, and use of action which the community considers as condemnable, even if there's no law that punishes it. And there are no common law crimes in the Philippines since the Philippines is a what? Civil law country. Okay. Okay, that's all for part 1. Thank you very much for listening. I hope you learned a lot. Thank you.